The television courtroom had never witnessed such a moment of pure, unfiltered arrogance, meeting its absolute destruction. I have sat behind many benches, but today, the arrogance in that room would be answered with something far heavier than words. Brenda Marshall, a 380-pound woman in her early 50s who had spent 6 years terrorizing small business owners with fraudulent lawsuits, sat in the defendant's chair with the kind of smug superiority that comes only from never facing real consequences. Her perfectly manicured finger pointed directly at me as she spoke words that would ultimately cost her $75,000 and years of freedom. "Maybe you should calm your hormones, Judge," she said, a sexist and ageist taunt. The room fell silent. For a television moment, this could have gone viral. But I do not do theater. I do the law. I do evidence. Brenda did more than insult the person in the robe. She revealed the contempt that animated her entire scheme. She did not just lose a case or suffer embarrassment in front of millions. What unfolded was the collapse of an enterprise. The next 30 seconds marked the judicial and investigative unmasking of a criminal operation that had extracted $412,000 from vulnerable immigrant business owners, ruining livelihoods and closing shops. The legal work done in that courtroom set off federal investigations across multiple states. It exposed a playbook of organized extortion, disguised as civil rights advocacy, and began the process of restitution for victims bankrupted by orchestrated shame campaigns. I spoke to her directly. The facts had weight, and the law demanded clarity. "You have a playbook," I said. "I have read it. The pattern is unmistakable. Target small businesses owned by immigrants who cannot afford to fight. Make impossible accommodation demands, record the refusal with hidden cameras, file lawsuits claiming discrimination, launch coordinated negative review campaigns, and then offer a settlement just below the cost of defending a trial. That arithmetic is cruelty turned into a business model." Brenda had perfected the mechanics. A failed stint in law school, 8 years as a paralegal, and a gut-level understanding of the expense of litigation taught her the arithmetic of fear. She found doctors to sign off on dubious medical claims for a fee, recruited accomplices to serve as scripted witnesses, created templates for defamatory reviews, and marketed a coaching product teaching others to replicate her scheme. She even had counsel drafting complaints with language calibrated to maximize panic. The operation was precise, profitable, and industrial. Yet she forgot a basic truth. The law leaves a trail when criminal intent exists. Patterns leave fingerprints. One of her victims, Linda Cho, refused to remain anonymous. Linda, a 39-year-old immigrant who saved and worked for 15 years to open a wellness spa, rejected the settlement. Instead, she meticulously documented evidence, hired a private investigator, and found other victims. Footage of Brenda walking, carrying groceries, pushing a cart, and playing with her dog shattered the narrative of incapacity. Documentary records revealed coordinated review campaigns, and bank records showed an organized flow of settlement proceeds. Civil law demanded a wider response. In court, I asked direct questions. When I inquired about the number of lawsuits she filed, the answer was clear: 47. Displaying the scrolling timeline of businesses, dates, and amounts made the architecture of her scheme visible, not just to proprietors, but to the public. Her rise from a mobility scooter contradicted sworn medical affidavits, and that single movement became a critical piece of evidence. I explained to the courtroom that ADA and state anti-discrimination laws protect real people from real harms, not as a licensing scheme for extortion. Using disability claims to extract money through manufactured indignation and reputational attacks crossed the line from civil grievance into organized criminality. The law distinguishes remedies for injury from punishment for systematic fraud. I described how Brenda identified victims by vulnerability, immigrant ownership, tight margins, and reputational exposure, applying coordinated pressure. Hidden camera performances, edited footage, fake reviews, paid witnesses, corrupt medical sign-offs, lawyers drafting fearsome complaints, and a digital marketplace teaching replication were her tools. I have seen bad behavior on my bench, but this was organized, repeatable, and monetized. Referral to federal authorities followed. The pattern suggested interstate wire fraud, tax violations, and organized extortion. Subpoenas, bank record tracing, and documentary evidence created a puzzle that fit together. What moved me most was the human cost. Bankrupted business owners, drained life savings, lost jobs, and frayed marriages. Compassion was weaponized against the vulnerable, and I would not allow it. The judgment awarded Miss Cho reimbursement of legal fees and punitive damages, and the lawsuit was dismissed with prejudice. Exhibits were transmitted to criminal investigators for potential charges beyond the civil claim. The courtroom does not prosecute, but it assembles a record prosecutors can follow. Vigilance, procedural safeguards, and cross-jurisdictional communication are necessary to prevent predators from exploiting isolation. To small business owners, I stressed prevention. Maintain time-stamped records, backup footage, organize correspondence, and cultivate quick legal contacts. Communities must document and share information. Courts must flag repeat plaintiffs, consolidate cases, and notify law enforcement. Regulatory boards must act swiftly on false medical documentation. Ethics in law and medicine is non-negotiable. Finally, I address the public. Exposure is part of accountability. When evidence is displayed clearly and responsibly, victims find each other, and law enforcement receives leads. Courage, persistence, and documentation restore faith in the law. To Brenda Marshall, the courtroom is not a stage for profit from victimhood. To Linda Cho and other victims, your civic bravery is a public good. Justice requires vigilance, collective action, and practical reforms to protect the vulnerable.